Welcome to the Republican Professor. I'm your host, Dr. Lucas J. Mather. Today, we're in a topic near and dear to my heart, homosexuals and the Second Amendment, the case of Tom Palmer versus District of Columbia, what the Democrats did to him. And I actually have met and spent time with Tom Palmer. We spent a weekend together at a Cato University event, and there is his John Johann Sebastian Hancock on. I don't know if you can see that. I guess maybe you can't. Let's see. There it is right there. See in the bottom of the screen there. Tom G. Palmer, D. Phil. He has a D. Phil from Oxford. At the time of this, which was 2018 summer, he was the director of Cato University, and I got a little diploma there. Kind of fun that he signed there. And he was a plaintiff in a lawsuit in 2014 in the District of Columbia, where he basically wanted the basic right of self-defense with an effective tool. And I did not know he was homosexual when I met him. Um, he's not effeminate, in at least publicly, he's not. He's very thoughtful. DPhil from Oxford. I think he's from Ukraine, maybe. I'm not sure if he was born there, but it seemed like he had a little bit of an accent. And it turned out he is like a Second Amendment diva. Basically, he's a Second Amendment celebrity that I don't know if I knew about at the time back in 2018 when we spent time together at this Cato event in San Diego. And I I've been wanting to do this episode for a long time. We did one in December called Women in the Second Amendment, where we went through the case of Jamie Cayetano, which went all the way to the Supreme Court, as you recall. Do you guys recall that? Jamie Cayetano went all the way to the Supreme Court. That was in December of 2018. This one is in 2019, sorry, 2014, after Heller, after McDonald. And I'm pulling up this filing, which is under michellelawyers.com. You can find it pretty easily. Palmer versus District of Columbia. And it's now there's multiple TRP connections here. First of all, michellelawyers.com. I had Chuck Michelle on the podcast multiple times. Chuck Michelle is the president of the California Rifle and Pistol Association, pro bono. And we talked to him on the podcast when Bruin was getting decided. Second Amendment Foundation, as you can see, is on the screen there as a plaintiff here. We had the founder of the Second Amendment, Alan Gottlieb, also on the podcast and had a great time talking about Sam Sloan, the Hawaii state senator who represented, I think, the Kahala area as the only Republican senator in Hawaii when I was living there and when I had to deal with some Second Amendment issues there. Um, and that was really a wonderful time. And then, of course, Tom Palmer, I just told you that we've had some interactions with him in person. And I was very impressed when I saw this lawsuit. And to me, it made me respect Cato a lot more. It's not that I disrespected it before, but uh, because of this lawsuit and the support that Tom Palmer put forward in the issue of Second Amendment public carry, that's some pretty serious street cred for Cato. Now, Cato has problems in other areas, most notably, I think, immigration. I think they're a little bit off on that, or maybe a lot off, and maybe a few other issues they're a little squirrely on. But the Second Amendment is a major issue, and if you get that right, we can be friends. And I'm happy to lend the support of the Republican Professor podcast to this case and the issue of homosexuals in the Second Amendment. Why would a homosexual want to have the right to keep and bear arms? Well, if what people say is true, that they faced some kind of increased, at least possible, they faced some kind of increased risk from a security perspective, I think that question answers itself. But I don't want you to come away from this thinking that I'm on the side of you need to have some kind of special risk to public carry. That's just not true. This was before Scullin, a senior judge who is a Republican, and this is the decision and order that was filed 26 July 2014. It's styled as Palmer versus District of Columbia versus DC. Background, we're on page 2, and I'm going to have the link in the description of the episode here on YouBoob and Orange podcasts. Oh, sorry, Banana pod. No, that's not it either. I know it's Tomato. No, that's not it. Grape. Grape pot. That doesn't sound right either. Apple. Apple podcasts. That's what it is. Okay. In their complaint, plaintiffs assert two claims for relief. In their first claim, plaintiffs allege that by requiring a permit to carry a handgun in public, yet refusing to issue such permits, which is what the Democrats did to Tom Palmer, yet refusing to issue such permits and refusing to allow the possession of any handgun that would be carried in public, defendants maintain a complete ban on carrying of handguns in public by almost all individuals. Do they care about homosexuals? No, they don't. 9, 10, 11, 12. Plaintiffs also contend that defendants' laws, that's DC, that's the Democrat DC, entirely Democrat. Defendants' laws, customs, practices, and policies generally banning the carrying of handguns in public violate the Second Amendment, yeah, to the United States Constitution, facially and as applied to the individual plaintiffs in this action, damaging plaintiffs in violation of 42 U.S. Code Section 1983. In their second claim for relief, plaintiffs allege that defendants' laws, customs, practice, and policies generally refusing the registration of firearms by individuals who live outside the District of Columbia violate the rights to travel and equal protection secured by the Due Process Clause of the Fifth Amendment to the United States Constitution, facially and as applied to individual plaintiffs in this action, damaging plaintiffs in violation of 42 U.S. Code, Section 1983. Plaintiffs seek relief in the form of an order permanently enjoining defendants, their officers, agents, servants, employees, and all persons in active concert or participation with them who receive actual notice of the injunction from enforcing DC Code section. And I'm not going to do the section. To ban registration of handguns to be carried for self-defense by law-abiding citizens. And by the way, why is this lawsuit possible? Because of Republicans, because of Republican president, appointed Republican judges on the Supreme Court who were confirmed by Republican Senate. And those Republicans on the Supreme Court enforced the Second Amendment against the Democrat districts, states, cities, localities from violating the constitutional rights of American citizens. It was Republicans versus Democrats. Republicans on the side of the Constitution in this issue, Democrats against. That's why Tom Palmer is doing this. He's lucky he got a Republican judge. He's lucky that George W. Bush was elected and that a Republican Senate was elected to confirm the Republican judges on the Supreme Court who in turn voted 5-4 in Heller versus DC 2008. You can look it up. And 5-4 in McDonald versus Chicago 2010. You can look it up. Both against entirely Democrat localities, completely violating the rights of American citizens. That's why. That's why he's able to do this. Before before June of 2008, okay, let's just say before July 2008, um, it was late part of June that Heller was decided, 2008. You had to, according to law in DC, register a handgun for it to be legal. And at the same time, there was a law saying you couldn't register your handgun. There was a policy that they enforced where no one could register their handgun. So you had to register a handgun, but then you couldn't. So you're a criminal either way you go, right? You try to register your handgun, you can't. If you don't register your handgun, you're a criminal. Either way, you're a criminal. Having a handgun is innocent conduct, though. That's what the Supreme Court found in Heller versus DC. Having a handgun for self-defense is not criminal activity. It is innocent conduct protected by the Second Amendment. Democrats have a long history of ignoring that and criminalizing innocent conduct. So here we are. Wherefore? Okay, so plaintiffs, we're on the bottom page two. Plaintiffs seek an order permanently enjoining defendants, their officers, agents, employees, and all persons in active concert participation with them who receive actual notice of this injunction from enforcing the DC Code. Blah, 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 blah. I'm going to skip down a bit. Okay. The parties do not dispute the basic facts that underlie this action. This relevant uh, ordinance code, DC Code, provides that no persons or organizations in the district shall possess or control any firearm unless the persons or organizations hold a valid registration certificate for the firearm. So, in other words, you need to ask permission. Mommy, can I have a firearm? Mommy, can I have it? Mommy, you go to the district and you say, Mommy, Mommy, can I have this firearm for self-defense? Can you please let me have it for self-defense? Can I please have it? And then the district says, Oh, I love you so much. No. Yeah. Republicans were like, there's something wrong about this situation. This is not how America is supposed to work here. Okay. Yeah. This is not North Korea. I know that there's a lot of people, and they're mostly like Democrats that would love us to be North Korea, but that's not how it works here. No, no, this is not Pyongyang. Okay, this is the District of Columbia, Washington, D.C., named after George Washington. No, that's not going to be happening. This is not named after Bob Pyongyang. Pyongyang, North Korea is named after Bob Pyongyang. You probably don't realize that. Did you know that? And did you you will I did some research on this. I did a deep dive on this. China is named after a guy named Mike China. I know. I was shocked too. I had no idea. I had bought this World Fact book at a swap meet, and I could not believe it, but it was a guy named Mike China. And I guess he was really popular in that part of the world. So anyway, let's keep going here. Now, this code provides that individuals who are not retired, and I almost thought that said a different word that you're not supposed to say. It's not polite, but the word is retired. Okay, sorry. Police officers may only register a handgun for use in self-defense within that person's home. Yeah, that exists because of Heller, because of Republicans, because of George W. Bush, and because of the Republican Senate and the judges on the Supreme Court. It's also George H.W. Bush who appointed Clarence Thomas and President Reagan who appointed Anthony Kennedy. So I got to give credit all the way down to all the presidents so let's keep going. Pursuant to this statutory legislation limitation, defendants distribute handgun registration application forms requiring applicants to give a brief statement of your intended use of the firearm and where the firearm will be kept. Oh man, what could possibly go wrong? Defendants maintain a custom, practice, and policy of refusing to entertain gun registration applications by individuals who do not reside in the District of Columbia. Defendants require gun registration applicants to submit proof of residency in the District of Columbia, like, the driver's license, rental lease or something like that, and, a deed to your home or something. Now, a first violation of the District of Columbia ban on ownership or possession of unregistered handguns is punishable as a misdemeanor by a fine of up to $1,000, imprisonment of up to 5 years, or both. Um, I've never heard of a misdemeanor being something that would send you to the slammer for 5 years. That doesn't sound like a misdemeanor to me. Okay, I'm just going to point that out. DC code, some people might say it's a wobbler, but why is it a wobbler? What's the wobbler about? If it's a ban on ownership and you have unregistered handgun, where's the wobbler thing there? I don't know where's the gray area here. Anyway, I want to point out something here. Um, the registration issue puts criminalizing this issue, it puts the innocence or guilt of someone to be determined based on the records that a third party has. How is that indicative of criminal activity if it's indicative if it's dependent on the records of a third party? So in other words, how do you know whether the registration has actually taken place? It's not my word. It's not like I go, yeah, I registered that. It's the word of a third party. The defendant. Oh, sorry. In this case, it's the defendant, but it would be the prosecutor. Excuse me. Whether you have good record keeping or not, why would my innocence or guilt have anything to do with that? Back in my day, to establish guilt of genuinely guilty conduct, it had to be something that I did, that I was completely in control of. Responsibility and control go together. If I'm not in control, I'm not responsible. You know? Hello? Hello? Is it just me? These administrative crimes make no sense, is what I'm trying to tell you. But that doesn't help. That doesn't stop the do-gooders. The do-gooders are always looking for some way to do good. I want to do some good by criminalizing innocent conduct. Okay, here's the DC code. Provides that no person shall carry within the District of Columbia, either openly or concealed, on or about their person, a pistol without a license issued pursuant to District of Columbia law, or any dangerous or deadly weapon capable of being so concealed. The first violation of this section by a non-felon is punishable by a fine up to $5,000 and imprisonment up to 5 years. Hmm. Former DC Code is empowered by the District of Columbia's police chief to issue licenses to carry handguns to individuals, including individuals not residing in the District of Columbia. However, it was defendant District of Columbia's policy, that's the Democrats, for many years not to issue such licenses. On December 16th, 2008, the District of Columbia's City Council and Mayor repealed the police chief's authority to issue handgun carry licenses. Accordingly, the District of Columbia lacks any mechanism to issue handgun licenses to individuals. What could possibly go wrong? So they're impinging on your right to keep the firearm in your home and to bear it in public for self-defense. What could possibly go wrong? Plaintiff Palmer. This is the homosexual man I was talking about, the guy that signed my little diploma and, you know, turned out he's like a Second Amendment advocate. Right on. Tom Palmer, D Phil from Oxford. And that's not Oxnard Community College, FYI. I mean, sometimes I get them confused. But apparently Oxford is in England. And I originally thought he meant Oxnard and he was just pronouncing it wrong. But no, I guess he went to somewhere in England for that. Now, Plaintiff Palmer, a resident of the district, would carry a functional handgun in public for self-defense, but refrains from doing so because he fears arrest, prosecution, fine, and imprisonment from the Democrats. It doesn't say from the Democrats. I put that in there, but I'm trying to make this clear, as he does not possess a license to carry a handgun. Plaintiff Palmer sought to register a handgun in the District of Columbia so that he might carry it for self-defense on or about May 12th, 2009. The defendant here, the Democrats, denied Plaintiff Palmer's application to register a handgun for the following reason. The intended use of the firearm as stated on your firearms, we're on bottom page 4, top of page 5, registration application. Quote, I intend to carry this firearm loaded and in public for self-defense when not kept in my home, unquote, is unacceptable. Oh, now, I want you to burn this into your mind here. Is unacceptable. That's unacceptable. Is unacceptable. Is unacceptable. Is unacceptable. Is unacceptable. This is what the Democrats are saying to a homosexual who wants to defend himself from crime. Is unacceptable. Is unacceptable. Is unacceptable. That's the Democrats. Is unacceptable. Per the Firearms Registration Emergency Amendment Act of 2008, which states that pistols may only be registered by DC residents for protection within the home. So, in other words, self-defense and home defense are not the same thing. Self-defense must go where the self goes, don't you think? Yeah? Don't you think we should move in that direction if we're doing really self-defense? And then we have Plaintiff George Lyon. Okay, so Defendant Lanier subsequently approved Plaintiff Palmer application to register a handgun for home defense. Okay, so he can keep it but not bear it. Plaintiff George Lyon, a resident of the district, would carry a functional handgun in public for self-defense, but refrains from doing so because he fears arrest, prosecution, fine, imprisonment, as he does not possess a license to carry a handgun in Washington, D.C. Plaintiff Lyon is licensed to carry handguns in the state of Virginia, Utah, and Florida. He has approximately 240 hours of firearm training. You think that's impressive? You think that's impressive to the Democrats? No, it's not. Of which 140 hours relate to specifically handguns. Plaintiff Lyon sought to register a handgun in the District of Columbia so that he might carry it for self-defense on or about April 8th, 2009. Defendant Lanier denied Plaintiff Lyon's application to register a handgun for the following reason. Quote, the intended storage and use of the firearm as stated on your firearm registration application, quote, carrying personal protection, keep at home or office is unacceptable, is unacceptable, is unacceptable, is unacceptable. This is the Democrats, is unacceptable. Protecting yourself is unacceptable, is unacceptable. Per the Firearms Registration Emergency Amendment Act of 2008, which states that it's unacceptable, which states that pistols may only be registered by DC residents for protection within the home. Defendant Lanier subsequently approved plaintiff Leon's application to register the handgun for home self-defense. At the time plaintiffs filed this action, plaintiff Raymond was not a resident of the district, was enrolled as a student at the Franklin Pierce Law Center in New Hampshire, was employed as a patent examiner, and owned a home in Waldorf, Maryland. Plaintiff Raymond holds a Master of Business Administration degree as well as a Master of Science degree in electrical engineering. He started various successful businesses and is honorably discharged Navy veteran. On April 6, 2007, District of Columbia Police stopped plaintiff Raymond for allegedly speeding. At that time, plaintiff Raymond held valid permits to carry a handgun issued by the states of Maryland and Florida. It still holds those permits. Although plaintiff Raymond was never charged with a traffic violation, he was charged with carrying a pistol without a license because his loaded handgun was located in his car's center console. Yeah. Plaintiff Raymond subsequently pled guilty to misdemeanor possession of an unregistered firearm and unregistered ammunition. He, what could possibly go wrong? You have to register your ammunition? Excuse me? Man, this is sad. He successfully completed a sentence of probation. Wow, that's really sad. That's unacceptable. In my view, that's unacceptable. Plaintiff Raymond would carry a functional handgun in public for self-defense while visiting and traveling throughout the District of Columbia. Well, and why would you want to do that? Maybe because of crime, maybe, but refrains from doing so because he fears another arrest and prosecution as well as fine and imprisonment, as he does not possess a license to carry a handgun in the District of Columbia. On June 26, 2009, plaintiff Raymond sought to register a handgun in the District of Columbia, but he was refused an application form because of his lack of residence in the district. You see what I mean? You get in trouble for not registering, but then you can't register. You see the game? You see the game? You see the lawfare? Plaintiff Amy McVeigh, a resident of the district, would carry a functional handgun in public for self-defense, but refrains from doing so because she fears arrest, prosecution, fine, and imprisonment, as she does not possess a license to carry a handgun in the District of Columbia. Plaintiff McVeigh is licensed by the state of Virginia to publicly carry a handgun. Plaintiff McVeigh sought to register a handgun in the District of Columbia so that she could carry it for self-defense. On July 7th, 2009, defendant Lanier denied her application to register a handgun for the following reason. Quote, the intended storage and use of the firearm were on page 7 at the top. As stated on your firearms registration application, I intend to carry the loaded firearm in public for self-defense when not stored in my home is unacceptable, is unacceptable, and is unacceptable. It's unacceptable. It's unacceptable. This is what the Democrats are saying to this woman. It's unacceptable. You want to protect yourself. It's unacceptable. She's trained. She's got a license to carry. It's unacceptable. Per the Firearms Registration Emergency Amendment Act of 2008, which states it's unacceptable that pistols may only be registered by DC residents for protection within the home. How are you guys doing? Plaintiff Second Amendment Foundation, Inc., SAF, came on the podcast, Alan Gottlieb, check it out, is a nonprofit membership organization incorporated under the laws of Washington, that's Washington State, with its principal place of business in Bellevue, Washington. SAF has more than 650,000 members and supporters nationwide, including the District of Columbia. The purpose of SAF include education, research, publishing, and legal action focusing on the constitutional right to privately own and possess firearms. and the consequences of gun control. SAF expends its resources encouraging the exercise of the right to bear arms and advising and educating its members, supporters, and general public about the law with respect to carrying handguns in the District of Columbia. The issues raised by and consequences of defendants' policies are of great interest to SAF's constituency. Defendants' policies regularly cause SAF to expend resources as people turn to it for advice and information. Defendants' policies, that's the Democrats. The Democrat defendant policies bar members and supporters of SAF from obtaining permits to carry handguns. Roman numeral 3, discussion, bottom page 7. The Supreme Court's decisions in District of Columbia versus Heller, 2008, and McDonald versus City of Chicago, 2010, directs the court's analysis of the plaintiff's claims. In Heller, the plaintiff mounted a Second Amendment challenge to a District of Columbia law that, quote, totally banned handgun possessions in the home, unquote, and required that any lawful firearm in the home be disassembled or bound by the trigger lock. What could possibly go wrong? What could possibly go wrong? So this DC law banned handguns because it required a registration and it also denied registration at the same time. And then also required that any other lawful firearm, like the long guns, well, you had to take them apart. Well, a lot of good they are if they're taken apart, or they had to be locked up. A lot of good that is too, if you need it for self-defense. In other words, it took the discretion out within acceptable bounds of common sense safety practices. And there is quite a bit of discretion there in the tradition. If you know, you know. The validity of the challenge measures depended as a preliminary matter on whether the Second Amendment codified an individual right or a collective right, whatever that's supposed to be. No one knows. After consulting the text's original public meaning, the court concluded that the Second Amendment codified a pre-existing individual right to keep and bear arms, and that the central component of the right was self-defense. Let me rephrase that a little bit. The Republicans on the court, it was only Republicans on the court that concluded that the Second Amendment codified a pre-existing individual right to keep and bear arms, and that the central component of the right was self-defense. By the way, this judge is a Republican, the one writing this, the one deciding this issue, defending Tom Palmer and his standing up for his right under the Constitution. Um, Furthermore, the court held that because the need for self-defense of family, and property is most acute in the home, the DC ban on the home use of handguns, quote, the most preferred firearm in the nation, unquote, failed constitutional muster under any standard of heightened scrutiny. The same was true for the trigger lock requirement. Yep, same is true. The Heller Court concluded that it did not need to undertake an exhaustive historical analysis of the full scope of the Second Amendment to dispose of this case, nor did the court have a reason to specify for future cases which burdens on the Second Amendment triggered which standards of review, or whether a tiered scrutiny approach was even appropriate in the first place. By any measure, the court found that the District of Columbia statute overreached. Now, I would say this really quick. There's a Republican on the DC circuit named Brett Kavanaugh at this time. And a couple of years before, in 2011, he had written a dissent in a case called Heller versus DC. Sorry, DC versus Heller. Sometimes it's called Heller 2. And in that dissent, Judge Kavanaugh says that there is not really a means ends heightened scrutiny analysis mandated by Heller, that Heller basically got rid of that for Second Amendment analysis. That view was later affirmed in New York State Rifle and Pistol Association versus Brewer in 2022. FYI, I just wanted to point that out. And at that time, he was on the Supreme Court. Well, so any measure, the court found that District Columbia statute overreached. Yeah. Now, 2 years later, McDonald The court evaluated a similar handgun ban and the city of Chicago had enacted. The question presented in McDonald, however, was not whether the ban infringed on Chicago's residents' Second Amendment rights, but rather whether a state government could be subject to the strictures of the Second Amendment. Yeah, the Democrats in the city of Chicago spent millions of dollars to take Otis McDonald, a black man's gun, away. That really happened. And during Obama's presidency, a black president who supposedly everybody liked because he was going to make us better. Well, he didn't make anybody better. Actually, he became the face of the Ku Klux Klan and taking guns away from black people in Democrat areas. It was the Republicans on the Supreme Court that said no, 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 no. And you have to give credit to the Republican president and the Republican Senate that put them there. Okay, let's keep going. Yeah, let's keep going. The answer to that question depends on whether which question, whether the Constitution applies to states, in terms of the individual rights context. The answer to that question depends on whether the right was deeply rooted in this nation's history and tradition and fundamental to our ordered scheme of liberty. Well, what did they decide? We're on page 9 at the top. The court stated in its decision, and Heller pointed unmistakably to the answer. Uh, the court explained that self-defense, recognized since ancient times as a basic right, was the central component of the Second Amendment guarantee. Thus, the court concluded that right restricted not only the federal government, but under the 14th Amendment, also the states. Having reached that conclusion, by the way, I would say this, the Republican 14th Amendment, it was fought entirely by Democrats, by the way, who want to take guns away from black people. The Democrats, 100 and what, 30 years later, 40 years later, 150 years later, are still trying to take black people's guns away. Now they try to soften that, and they would try to take guns away from homosexuals. They try to soften that. Why do they try to soften that? Well, they try to soften that by saying we want to take it away from everybody. But it makes you wonder, so they really wanted to take it away from vulnerable people. That's who they really want to take it away from. And there's they want to make as many people vulnerable as possible. So it has morphed a bit, but it's still sick. It's a weird and sick political philosophy. We're fighting back against it for the sake of the health of our republic and the health of people. It's not good for our flourishing. It's maladministration at its worst. So, um, having reached that conclusion, the court remanded the case to the Seventh Circuit for an analysis of whether, in light of Heller, the Chicago handgun ban infringed on the Second Amendment right. Now, neither Heller nor McDonald speaks explicitly or precisely to the scope of the Second Amendment right outside the home or what it takes to infringe on that right. However, both opinions, in the very least, point in a general direction. As the Ninth Circuit recently noted in Peruta, now this was the original Peruta in 2014, and that would be the 742nd volume of the third series of the Federal Reporter starting at 1144, 2014, Ninth Circuit, addressed, I think that was Judge Diamond O'Scanlan's writing there, who's also a Republican, addressed the statutes very similar to the ones at issue in this case. Quote, to resolve the challenge to the district DC restrictions, the Heller majority described and applied a certain methodology. It addressed first whether having operable handguns in the home amounted to keeping and bearing arms within the meaning of the Second Amendment, and next, whether the challenge laws, if they indeed uh, did burden constitutionally protected conduct, infringe that right. Now let's take a look at this footnote, footnote 2. The Peruta court addressed the issue of whether a responsible, law-abiding citizen has a right under the Second Amendment to carry a firearm in public for self-defense. As a preliminary matter, the court noted that, quote, California generally prohibits the open or concealed carriage of a handgun, whether loaded or unloaded, in public locations. However, an individual could apply for a license to carry a concealed weapon in the city or town in which he worked or resided. To obtain such a license, however, the applicant had to meet several requirements, including a demonstration of good moral character, completion of a specified training course, and establishing good cause. Yeah, the good old good cause. Now, the plaintiff challenged San Diego County's procedures for obtaining a concealed carry license, in particular its definition of good cause. Yeah, and that was struck down in the original Peruta when before the Democrats got a hold of it en banc, um, and it was reaffirmed by Republicans on the Supreme Court in Bruin. Democrats are still fighting Bruin, though, and you got to be aware of that. In analyzing, or on page 10 at the top, the issues in this case, the court must apply the two-step approach that the District of Columbia Circuit set forth in Heller versus District of Columbia Heller 2. That's at the 670th volume of the Federal Reporter, third series, starting at page 1244, D.C. Circuit 2011. That's that case that I said that Judge Kavanaugh was writing in dissent. You want to check out that dissent. Actually, we covered that dissent on this podcast as it pertains to assault weapons, so-called assault weapons. The first question requires this court to decide whether the restricted activity, in this case, a restriction on a responsible, law-abiding citizen's ability to carry a gun outside the home for self-defense, falls within the Second Amendment right to keep and bear arms for the purpose of self-defense. To determine the precise methods which that right's scope discerned, the Supreme Court has directed in both Heller and McDonald that courts must consult both text and history. And of course, that's been carried forward in Bruin. Remember, this is in 2014, okay? Now, as the court noted in Heller, quote, constitutional rights are enshrined with the scope that they were understood to have when the people adopted them, whether or not the future legislatures or even future judges think that that scope is too broad. There's a separation of powers issue there, don't you see? You see that, right? The legislatures, the legislative power doesn't have authority here. The judicial power does not have authority here to well, the legislators don't have the authority to infringe these rights. The judges don't have that authority either. And in fact, the judges have a step further. They have a positive duty, I think, in the judicial power to protect the right in a case or controversy, to protect the individual from the deprivation of those rights. Now, to arrive at the original understanding of that right, he continues, we are guided by the principle that the Constitution was written to be understood by the voters. Its words and phrases were used in their normal and ordinary as distinguished from technical meaning, unless evidence suggests that the language was used idiomatically. Now, that would, let me take a look at footnote 3 really quick. Okay, I'm going to skip footnote 3. We're on page 11 at the top. Of course, the necessity of this historical analysis presupposes what Heller makes explicit. The Second Amendment is not unlimited. Furthermore, it is not a right to keep and carry any weapon whatsoever in any manner whatsoever for whatever purpose. Rather, it's a right subject to traditional restrictions, which themselves, and this is a critical point, tend to show the scope of the right. Now, um, so as the court noted in Peruta, the Second Amendment secures the right not only to keep but also to bear arms, and as the Supreme Court explained in Heller, um, bear meant to carry. Now that makes sense. Yet not carry in the ordinary sense of conveying or transporting an object as one might carry groceries to the checkout counter or garments to the laundromat, but carry for a particular purpose, confrontation. Yeah. According to the Heller majority, the natural meaning of, quote, bear arms, unquote, was The one that Justice Ginsburg, now this is ironic, pay attention to this, Justice Ginsburg, she provided this definition in her dissent in Muscarello versus United States in 1998. That's a Supreme Court decision. And she said that is to wear, bear, or carry upon the person or in the clothing or in a pocket for the purpose of being armed and ready for offensive or defensive action in the case of conflict with another person. And she was quoting Black's Law Dictionary in 1998. At least that's what it says here. Furthermore, bearing a weapon inside the home does not exhaust the definition of carry. We're on page 12 at the top. For one thing, the very risk occasioning such carriage confrontation is not limited to the home. Moreover, I'm skipping over the citations because it would take too long. Moreover, it is beyond dispute that, quote, the purpose of conflict, at least the sort of conflict for which one would wish to be armed and ready, is just as menacing and likely more so beyond the front porch as it is in the living room. Thus, to speak of bearing arms within one's home would at all times have been an awkward usage. In addition, the Heller Court stated that the Second Amendment secures the right to protect oneself against both public and private violence, thus extending the right in some form to wherever a person could be exposed to public or private violence. Moreover, in the Heller Court emphasized that the need for the right was most acute in the home, thus implying the right exists outside the home, though the need is not always as acute. The Second Amendment protects a personal right to keep and bear arms for lawful purposes, most notably for self-defense within the home. That's a quote. However, Heller also pointed out that, quote, laws forbidding the carrying of firearms in sensitive places such as schools and government buildings, unquote, is presumptively lawful. Finally, that's dicta, though. That's dicta. That's not part of the holding. It's called Heller dicta. Dicta is not essential to the holding, so it's entitled to less weight, as precedent. Now, finally, both Heller and McDonald identified the core component of the right of self-defense. We're on page 13 at the top, which necessarily takes place wherever a person happens to be, whether in a back alley or on the back deck. The to confine the right to be armed to the home is to divorce the Second Amendment from the right of self-defense described in Heller and McDonald. This court agrees with the Ninth Circuit statement in Peruta, the original Peruta, the Republican one, that these passages alone, though short of dispositive, strongly suggest that the Second Amendment secures it right to carry a firearm in some fashion outside the home. Reading those lines in light of the plain meaning of the definition of, quote, bear arms, unquote, elucidated above, makes matters even clearer. The Second Amendment's right could not rationally have been limited to the home. Although people may keep arms, right, in the home for self-defense, for defense of self, family, property, they're not more sensibly said to bear arms um, in non-domestic settings. And again, that definition of bear arms, carry weapons upon the person in the clothing or in a pocket. The plain text of the Second Amendment does not limit the right to bear arms to the home. There's citations here. I'm skipping the citations. To speak of bearing arms solely within one's home would not only conflate bearing with keeping in derogation of the court's holding that the verbs codified distinct rights, but also would be awkward usage given the meanings assigned to the terms by the Supreme Court. In addition to the textual analysis of the phrase bear arms, the court in Heller looked to the original public understanding of the Second Amendment right as evidence of its scope and meaning, relying on the important founding era legal scholars. Page 14 at the top. Examining the public understanding of the Second Amendment in the period after its ratification, because that sort of inquiry is a critical tool of constitutional interpretation. Based on its historical review, the court found support for the proposition that the Second Amendment secures an individual right to carry in case of confrontation means nothing if it's not the general right to carry a common weapon outside the home for self-defense. Furthermore, as the court in Peruta correctly pointed out, quote, with Heller on the books, the Second Amendment's original meaning is now settled in at least two relevant respects, unquote. First, here's a continuation of the quote. Heller clarifies that keeping and bearing arms is and has always been an individual right. Second, the right is and has always been oriented to the end of self-defense. After an exhaustive summary of the text and history of the Second Amendment, the Ninth Circuit in Peruta, and that's the original Peruta, the 2014 Republican one, concluded that the carrying of an operable handgun outside the home for the lawful purpose of self-defense, though subject to traditional restrictions, constitutes bearing arms within the meaning of the Second Amendment. As the Ninth Circuit noted, this conclusion is not surprising in light of the fact that other circuits have reached the same result. Okay, now he's just citing those. This court, joining most of the other courts that have addressed the issue, reached the same conclusion. So basically, um, he was looking at other circuits and what they were doing with this. Now, this did go further in the DC circuit, and you want to take a look at the Wren case written by a Republican, Judge Griffith. That's an excellent decision, and that was a great setup for what we have protected in New York Rifle and Pistol Association versus Bruin. Finally, as the Peruta court pointed out, understanding the scope of the right is not just necessary, it's the key to the court's analysis, because if self-defense outside the home is part of the core right to bear arms and the District of Columbia's regulatory scheme prohibits that exercise of the right, no amount of interest balancing under a heightened form of means and scrutiny can justify the District of Columbia's policy. That's exactly what Judge Kavanaugh said in dissent in Heller 2 in the 670th volume of the third series, The Federal Reporter. Um, yeah, and it's not surprising he signed on to Bruin because that's what Bruin said. Well, the very enumeration of the right takes out of the hands of the government, even the third branch of government, the power to decide on a case-by-case basis whether the right is really worth insisting upon. That's a famous quote from Justice Scalia. Thus, having concluded that carrying a handgun outside the home for self-defense comes within the meaning of bearing arms under the Second Amendment, the court must now ask whether the District of Columbia's total ban on the carrying of handguns within the district infringes that right. The question is not difficult to answer. As the Seventh Circuit stated in Moore versus Madigan, a blanket prohibition on carrying guns in public prevents a person from defending himself anywhere except inside his home. So, a substantial curtailment of the right of armed self-defense requires a greater showing of justification than merely that the public might benefit on balance from such a curtailment, though there is no proof that it would. This does not mean that the government cannot place some reasonable restrictions on carrying of handguns. For example, when a state bans guns merely in particular places, such as public schools, although I think that there's a problem with that too. What about teachers? What about teachers? A person can preserve an undiminished right of self-defense not by entering those places, since that's a lesser burden. The state doesn't need to prove such a strong need. Well, this is all speculation and it's dicta. And don't get me started on public schools, for God's sake. Anyway, I keep going. The District of Columbia, what, teachers don't have a right to self-defense? How's that worked out? That hasn't worked out very well, has it? Yeah. Yeah, I'd say that's a failed policy. The District of Columbia appears to be the only jurisdiction that still has such a complete ban on the carrying of ready-to-use handguns outside the home. That does not mean, we're on page 16 at the top, that other jurisdictions are indifferent to the dangers that the widespread carrying of guns. Um, that does not mean that other jurisdictions are indifferent to the dangers that the widespread public carrying of guns. Wow, that's a mistake there. No wonder that was so awkward. That does not mean that other districts are indifferent to the dangers that the widespread public carrying of guns. That's not a good sentence there, Judge. Then you have a semicolon. Rather, those jurisdictions, quote, have decided that a proper balance between the interest in self-defense and the dangers created by carrying guns in public is to limit the right to carry a gun to responsible persons rather to ban public carriage altogether. In addition to the usual prohibitions of gun ownership by children, felons, illegal aliens, lunatics, and sensitive places such as public schools, no, no. The propriety of which was not questioned in Heller. I don't know of any bans in public schools that were in place at the founding. Do you? Some states sensibly require that an applicant for a handgun permit establish his competence in handling firearms. Some states also permit private businesses and other public private institutions such as churches. Not a good idea. Not a good idea to ban guns from the premises. Not a good idea. How's that worked out? How's that worked out in places of worship? No, not a good idea. That's being litigated right now at the Supreme Court. The Lopez case. Yep. Alan Beck came on the podcast. He's the lead attorney, leading the charge. He's going to win. He's going to win. Private institutions and public carry. That's in Hawaii. It's in the Ninth Circuit. Keep your eye out for that in light of Heller. McDonald and their progeny, there's no longer any basis on which this court can conclude that the District of Columbia's total ban on the public carrying of ready-to-use handguns outside the home is constitutional under any level of scrutiny. They're very good, very good, very good. The level of scrutiny have nothing to do with it. Therefore, the court finds that the District of Columbia's complete ban on the carrying of handguns in public is unconstitutional. Accordingly, the court grants plaintiffs' motion for summary judgment and enjoins defendants from enforcing the home limitations of DC Code and enforcing the DC Code, blah, 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 unless and until such time as the District of Columbia adopts a licensing mechanism consistent with constitutional standards, enabling people to exercise their Second Amendment's right to bear arms. Yeah! Furthermore, this injunction prohibits the district from completely banning the carrying of handguns in public for self-defense by otherwise qualified non-residents based solely on the fact that they are not residents of the district. We're on page 17 at the top. I'm going to check out footnote 4. The court notes that in Heller versus District of Columbia, Judge Borsberg recently dismissed all of the plaintiffs' challenges to the constitutionality of the district's firearm laws with prejudice, except for their challenge to the vision requirements for gun registration, which, because he decided that challenge was based on jurisdictional grounds, he dismissed without prejudice. Okay, that's a pretty big footnote, and I don't think we need to really get into that. Unless you want to, you could. Now, the page 17, letter C, equal protection of the right to travel challenges. Okay. Now, this pertains to the plaintiff Raymond, the only one that had been arrested and charged and convicted. Poor guy was pressured to plead guilty to that bull crap. Um, the only non-resident individual plaintiff, SAF, insofar as some of its members who are not residents of the District of Columbia would like to carry a handgun in the district where they are, argue that defendants' practice of refusing to issue a permit to carry in the district based solely on the fact that the person is not a resident violates the right to travel and equal protection clause of the 14th Amendment. This court has difficulty seeing how these challenges under the circumstances of this case are not coextensive with Plaintiff Raymond's Second Amendment challenges to the current district laws regarding the complete ban on carrying handguns in public. Furthermore, as things now stand, Plaintiff Raymond and all others who are not residents of the district are treated exactly the same as residents of the district insofar as the district has a complete ban on the carrying of handguns in public for self-defense. Thus, to the extent that the plaintiff Raymond's right to travel and equal protection claims are not coextensive with the Second Amendment claims, this court finds that those claims are not ripe. These claims are not ripe. Conclusion. Having reviewed the parties' submissions and applicable law for the above stated reasons, the court hereby grants plaintiffs' motions for summary judgment and denies defendants' cross motion for summary judgment. And this court further orders the defendants, that is the Democrats, the Democrat defendants, the Ku Klux Klan sympathizers in the Democratic Party, their officers, agents, servants, employees, and all persons in active concert or participation with them who receive actual notice of this memorandum decision order are permanently enjoined from enforcing DC Code, blah, 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 to ban registration of handguns to be carried in public for self-defense by law-abiding citizens. And and what? And further orders the defendants, their officers, agents, servants, employees, and all persons in active or participation with them who receive actual notice of this memorandum, decision, order, or permanently enjoined from enforcing DC law, blah, blah, and blah, blah, blah. It is so ordered, and this is July 24th, 2014. Frederick J. Scullin, Senior United States District Court Judge. Mr. Frank Scullin, thank you so much for your service. Oh my gosh. Oh, thank you, Frank Scullin. Thank you, brother. Nice job, dude. Frank Scullin was appointed by George W. Bush, and he assumed office in February of 1992. He was appointed by a Republican. Okay, around and about the same time that Justice Scalia got on the Supreme Court. Praise the Lord. Thanks for joining me on the Republican Professor podcast. I've been your host, Dr. Lucas J. Mather, for this special edition of a look back on the topic of homosexuals and the Second Amendment. As we've seen in this episode, the Democrats do not really care that much about vulnerable people who need to protect themselves from not only criminals in a private context, but public criminals. That is the agents of the government who work for and in concert with Democratic Party purposes and agendas to refuse to protect your right of self-defense under the Constitution, a pre-existing right, an individual right to keep and to bear arms for self-defense. And they are more than happy to criminalize homosexuals for wanting to protect themselves, as we've seen with the case of Tom Palmer. We'll see you next time. It's 3 February 2026 years after Jesus. It's a Tuesday. We'll talk to you later.